We do have about 3 more questions to get through, and I want to leave ample time for Q&A, but if there's something you'd like to address.
Well, I'd like to just Marianne put a huge amount on the table here, and I'd like to address 2 points, and I'll leave the rest for later. So it is, very easy to say that there is, the fact that a state is weak doesn't convey any authority to use force on its territory. And I'm sure there are a lot of, high-minded sounding opinions of the ICJ that one can cite for that proposition. There's a perfectly beautiful movie made in 1938 called Grand Illusion, which ends with 2 French POWs who've escaped running across a field, and German soldiers, this is in World War I, pointing their rifles at them, and they're about to shoot them dead, and one of them says, "Wait, they're in Switzerland." And that's the end of the movie. It's one of the great movies on any subject ever written, ever made, certainly on the laws of war. And the point of that ultimate scene is how quaint the old ways are. And this was made in 1938, just before those old ways' quaintness was very much revealed. The idea that a country that is using force is going to stop because somebody makes it into the territory of some other country is, as a general matter, a difficult proposition. And when you're dealing with countries that have no capacity or willingness to exercise the law enforcement functions that Mary Ellen is insisting is the only legitimate way, is frankly fantastical. If there is a large and coordinated group of people who are attacking us from an ungoverned space in the world, and the country that has notional sovereignty over that space is unable or unwilling to do something about it, where that country is able and willing, like France, England, Egypt, it doesn't even have to be democratic countries, right? There is a very, very strong principle of respect for their, territorial sovereignty. That principle has to give in certain situations, and one of them is the situation in which you are simply, resigning yourself to having no capacity to address the problem if you consider that line between where the soldiers are, they've made it to Yemen, gotta put down the guns. It's not a position that comports with the reality in which states live. And I'm unaware, by the way, of any state facing a serious national security problem and a serious security threat that has honored that principle.
Let me ask you a couple of questions together in a short period of time. How does the ban on assassinations, the U.S. domestic law ban on assassinations, play into this? And then, relatedly perhaps, maybe not, what about CIA involvement? I mean, why are they unprivileged enemy belligerents just the same way Al-Qaeda is?
Well,
who wants to go first?
I guess I'll address this one first. So the assassinations ban is a peculiar instrument, and it forbids categorically assassinations which it does not define. And I believe it was always understood that whatever assassinations mean, it only means something that is unlawful under domestic law, since it's not a term of international law. And so, here's, I think, the broad parameters of what it means. It clearly doesn't mean somebody who's a combatant, because that is authorized, by domestic law. It clearly doesn't mean, I think it does mean, the killing of a political leader of some country. I think it has, under domestic law, very unclear meaning, and in any event, is, after all, just an executive order that is, presumably interpretable by the executive branch as such. So I think there's no particularly satisfying definition of what it encompasses. I think it's very clear that the executive branch institutionally, both under the last administration and under this, does not consider it an impediment to operations of this nature.
Just very briefly, I'm not an expert on U.S. domestic law on this question, and I don't speak on points of law about which I am not an expert. But I will refer you to Harper's Magazine, Scott Horton, who is an expert on these topics. He has an excellent piece on May 3rd in which he finds that the U.S. designation, the U.S. targeted killing program, as carried out by the CIA, is clearly in violation of the 1947 statute that set up the CIA. So I refer you to that and many other excellent pieces on the domestic law involved. And I might just pick up one other U.S. domestic position, because Ben thinks it's fantastical that we would reserve or restrict targeted killing to the battlefield and not allow it against those who would create serious challenges to the United States through their acts of terrorism. But that's exactly what Ambassador Indyk said during he was a Bush administration appointment as ambassador to Israel. And in July 2001, he made it very clear to Israel that the United States legal position is that targeted killing is unlawful.
Now that we were running late, I'll ask each of you whether you want to say anything else before we turn it over to the audience. Okay, go.
Just one word on self-defense.
Sure.
The other thing that we didn't really talk about was, well, maybe we did. Let's see what your questions are. If there are questions, actually, we did. Right.
I have two questions. One for Ellen and one for Mr. Wittes. For Mary Ellen, I would ask this. I know you're very familiar with the work of Professor Muravinsky, this great scholar, who I have often battled with, but nonetheless, he has a theory of what he calls extraterritorial law enforcement, which he gives in connection with a war going on in State A, but where there are individuals in the adjacent state, State B, who are, let's say, lobbing missiles at the armed forces of a particular country in State A. And he maintains that, at least across the border, if you do have people who are attacking your armed forces, he maintains under the theory of extraterritorial law enforcement that there is a right to go after them for specific self-defense purposes. Now, obviously, Afghanistan and Pakistan is a clear example of that. I'd be interested in your take on his theory. And for Mr. Wittes, I would just ask you this. If a spy agency from another country, or if an armed force from another country decided it was going to send drones over the United States and target and kill people within the United States that it considered to be a threat to their security, presumably under your theory that would be perfectly acceptable. Is that your view?
No, not at all. And believe it or not, there's no conflict between that view and... So look, the United States has the capacity to cooperate and to neutralize lethal threats to other countries. It has robust law enforcement capacity, and it has shown no dearth of willingness to arrest, prosecute, and detain people accused of material support of foreign terrorist groups directing attacks at other countries when asked to cooperate by other countries. And my view is that the territorial sovereignty, the restriction on military operations on the sovereign territory of a country gives way when that capacity is unavailable. And so, I think if a foreign government comes to the United States government and says, Ben Wittes poses a lethal threat, he's a member of a combatant force against our, and here's the evidence of that, and they have recourse through that, and the U.S. government is quite aggressive in those situations. Now, and for exactly that reason, there are, more than 150 countries in the world in which we do not engage in lethal force, in lethal force of the type that I'm defending, in a few discrete contexts. And the discrete contexts in which I'm defending them are A, in a battlefield setting, as Mary Ellen concedes is appropriate, and B, in situations in which people have taken, combatants, people fighting us, attacking us, have taken safe haven in an ungoverned space where they are not reachable by conventional means. And I think if you imagine, for your hypothetical to actually present itself in a challenge to what I'm arguing, you'd have to imagine some area of the United States in which federal power does not meaningfully reach. And that's,
Texas border.
Wow, and that leaves 42 countries in which Ben believes the United States is or is
No, I said more than 100.
Alarming because, as far as I was able to gather, we're using lethal force unlawfully in 3 countries right now. So this is, but notice the argument that Ben uses. It's often out there in these discussions, unable or unwilling. Valerie, that is not the legal test of whether the country is unable or unwilling. And he also says that these are ungoverned territories. There's only one country in the world that the United States officially believes, or is our official position, is ungoverned, and that is Somalia. And even in Somalia, because we are not involved in armed conflict hostilities in Somalia, and heaven knows we do not want to be, if we were to undertake any action on the territory of Somalia, it would have to be of a police enforcement action, such as we have the right to do with regard to pirates, under a Security Council resolution. We could perhaps, and I would prefer to see a Security Council resolution, but under a theory of countermeasures, violate Somalia's right of non-intervention by using law enforcement measures to go after, to try to attempt to arrest and charge with criminal wrongdoing those persons for whom we have sufficient evidence that they're involved in terrorist activity. But that's a lot of this, and an exceptional case. It probably doesn't apply elsewhere. Elsewhere, we have to try to model the good citizenship that we have long felt is our greatest contribution to the international community. And that's what Valerie's talking about. We don't want other countries to say, well, if the U.S. does it, we can do it. We all know how China describes its enemies, how Iran describes its enemies. They have drones. Do we really want those to be the rules of the game? No. We need to start modeling and complying with the rules we want to see everybody go along with. And if we just look at the data, we'll find, just as with the torture case, not only are we talking about the lawful way to act, we're also talking about the moral and effective way to act. This is not asking a lot. It's just putting the case to the American people. It's not as dramatic as with drones, but it's going to work in the long run. And that's what I would actually say to Norm Dinstein. He doesn't have a case for sending commandos onto the territory of a country that he says is not able or willing to control their land. We have this in a number of International Court of Justice decisions, and I, as an international lawyer, look to the International Court of Justice as the chief legal organ of the United Nations with special expertise in interpreting the United Nations Charter, with 9 judges of great respect and great knowledge of international law per se. I don't dismiss that court, as I think we've heard them do. The International Court of Justice has made it clear in Congo, Uganda, in Nicaragua, in Corfu Channel, that you police according to, on your border to defend and to take care of these kinds of issues. You cooperate with the territorial state, that which does, by the way, have a long-term beneficial impact on that state, and you reserve the use of lethal force for targeted killing or armed conflict hostilities for actual armed conflict hostilities.